Hello and welcome to this Legal Week Q&A in association with Nuix. With me here in the studio is William Mitchell, EMEA Regional Counsel of Nuix, which specialises in data intelligence and analytics. We're going to talk about data privacy in the light of the recent introduction of GDPR. Welcome, William.
It's a pleasure to be here, John. Thanks.
So now it's a couple of months on. What have we learnt about GDPR and the regime and how it will work?
Well, unfortunately, not nearly as much as we'd like to. Things are really just too new to understand how effective the penalty regime and the damage exposure will be, which people consider to be probably the two prime movers in terms of motivating companies to re-examine their data privacy regimes and put the kind of mechanisms in place that's required. Until we see those first actions, until we see the big penalty exposed, because everybody's talked about how much the penalties could be, until we see whether the ICO in the UK or the other data protection authorities really goes the limit, makes examples of companies that don't take it seriously or not, we won't know how much motivation there will be.
And so what have companies done up to now then, do you think? What is the level of compliance?
Well, I think you see it's spotty. I think a lot of us have the experience of looking in our email inboxes and seeing new privacy policies every day from virtually everybody we deal with online, and every website has got a new button to click. So it's clear that people are doing something. I think those things are relatively easy to do, and companies are concerned about appearing compliant, whether underneath the surface they've really done everything that's required or not.
So there's more to be done, and what would you be recommending companies to be doing now?
Oh, well, there's a huge amount that's required to actually substantively comply. You have to know what personal data you have of people. You have to know where it is in your systems and how it's protected, and ensure that it's protected to the kind of high standard that GDPR sets for protecting data. And you have to know how you're going to respond if something bad happens. That bad thing could be simply somebody asking for access to their information, which they're entitled to. That can be an administrative problem, but I think the real exposure is going to be when there are breaches. As soon as there's a breach where significant amounts of protected personal data is exposed, then you're going to see the ICO and the other DPAs all over those companies, and if they haven't taken the basic steps to protect that data, I think we would expect them to get hit hard.
Right. So, and we're thinking about GDPR as a European measure. But it's a reflection of how society is going. So, or politics. What influence is it having on the rest of the world? Are other regulatory authorities looking at this and thinking they should do the same thing?
Oh, absolutely. And you see this in Australia, you see this in India. China is considering similar kinds of laws. Individual states in the United States now have data protection breach notification requirements. It's hard to even think about how multinational corporations are going to cope with this, because you can't build a different protection mechanism, a whole different set of policies and procedures depending on whether the data subject lives in Australia or the UK. But the laws are very, very different from place to place. So I think one of the things GDPR does at this point is to set the bar high. None of the proposed legislation in other parts of the world seems to be more draconian, more protective. So the EU is really leading the way.
So you use that as a gold standard, and even those companies without much exposure in the EU should be taking note.
Well, yes. The territorial scope of the GDPR is not completely clear, and that's one of the things we're looking for guidance on. But it's clear that in some cases, at least, the mere processing of personal data in the EU, where the processing happens in the EU, brings that personal data within the realm of GDPR's protection, even if that personal data is about someone who lives somewhere else. So we don't know how that's going to play out, because we could have people from all over the world coming here to the UK or anywhere else within the EU and asserting claims under GDPR. we just don't know what the impact will be of that.
So it really is very much the beginning of what looks like a pretty long process.
Well, I think as you suggested, this is part of a reaction, I think, to 21st century world where our data is out there all the time and we're swiping cards and giving our information right and left. And we know that there have been some significant abuses of that trust, that companies have passed on that information without telling us. They've sold it, they've repackaged it and sold it and made lots of money off us, and we don't know what that's about. And of course, there's the Facebooks and Googles of the world who are in that business. And clearly they're at the crosshairs of the focus here.
Yeah, so it's fascinating. And so what's your predictions? What are your predictions for the next, the medium term, over the next couple of years? How will this all pan out?
Well, I think that we'll see some jurisdictions that don't bother with it at all, and I would expect that from the U.S. federal government. But we will see when we have those first enforcement actions. I think we will see a second wave. Right now, we have companies, a few, perhaps, hopefully more than just a few, who are taking this quite seriously. But a lot of them haven't done so. And there are examples we probably shouldn't get into specifics here, but there are companies that are there. We will see more and more companies coming up to taking it seriously once we see those penalties imposed.
So it's a second wave of compliance.
Right, and the ICO here in the UK has provided a huge amount of guidance to companies with respect to what they see GDPR to be about in the UK. Some of that guidance is not internally consistent and perhaps not as practical as eventually it will become. But organizations like the ICO are taking this very seriously. We know they have staff, they have ample staff, they intend to investigate, they intend to to impose penalties when it makes sense. So we'll see that kind of action. And then the GDPR does contemplate standard damage claims in court. It's not clear how that would work, but when we see breach situations, an Equifax scenario or something where we got tens of thousands of names and credit card numbers released somehow, then we're going to see, I think, real damage claims too. We'll have the plaintiffs bar from the United States suing everybody they can think of, and that'll be another lever to get things to change.
But I suppose the final question, data is never going to be completely safe, is it? But leaks will happen. But presumably, if you've done all the things that you should have been doing in order to protect that from happening, that puts you presumably in a much stronger position.
Well, we certainly hope that there'll be some sort of good faith consideration when something bad does happen, because once data becomes digital, as you suggest, it's impossible to completely protect it unless you only have one copy on a USB stick somewhere in the desert. And that's not the real world. The whole data is powerful because we share it and we use it. So we need to be able to do both. And I think this entire information governance and data privacy movement is an attempt to strike that kind of compromise. To say, what do we need to do to still benefit from all that data?
Thank you, William. It really is a fascinating topic.
It's been a pleasure.
And thank you for watching this Legal Week Q&A in association with Nuix.